Everyone, and welcome to Multi-Jurisdictional Employers Part 4, Marijuana and Other Drug Testing in the Workplace. Thank you for joining us today. We're going to hop into it in just a second here. If you are here and wanting HRCI credit, we will have that code for you at the end of the session today. So hopefully you can hang out with us and get that code at the end. Next slide. My name is Nicole Atala. I am a partner here at Polaro Mazza. I have been working here for, 15 years now, and I counsel clients on a broad range of labor and employment issues. But what is very common about most of our clients, particularly because we are situated in the DC metro area, is these issues of multi-jurisdictional employers. So we're pretty well versed in that. And this is my colleague, Sarah.
Hello, everyone. Good afternoon. So I am also an attorney in the Labor and Employment Group. I work with Nicole and our team advising employers on a wide range of workplace-related matters. Obviously, as Nicole mentioned, a big portion of our clients are government contractors. So, anything related to that industry and field, we obviously counsel clients on, and as I'm sure many of you may be who are joining the webinar, when it comes to government contractors, there is a whole set of regulations and additional things to worry about and ensure that you're compliant with. And so today we're going to focus primarily on the world of marijuana and drug testing, as well as the Drug-Free Workplace Act.
All right, next slide. All right, so about Polaro Mazza, if you are not familiar with us, and I think many of you are, we are a full-service law firm that, a good number of our clients are government contractors, but we also have clients that work on the commercial side as well, and that, some that just do commercial, some that do a mix. We don't just do government contracts and labor and employment. We have a great corporate group. We have a great litigation group and construction group. And oftentimes, just like with these multi-jurisdictional issues, our practice groups are constantly working together to help, really shore up being those trusted legal advisors for our clients. We want you to call us. And if we can't do it for you, we're going to help you find someone who can help you achieve whatever goal you're trying to achieve. Next slide. All right, so what are we going to do today? Let's get to the fun stuff. We are going to take a look at multi-jurisdictional issues related to drug testing and drugs in the workplace. When I started practicing 17 years ago, the clients would always say, hey, someone failed a drug test. We don't have to hire them. And I'd say, yep, you don't have to hire them, go on your merry way. Or someone told me they have a drug problem and we don't want to deal with this, so we're going to cut them loose, and no issues there. Over those 17 years, this area has evolved rapidly. So we're going to take most of this is, by the way, at the state level, which is why it's such a big multi-jurisdictional issue for employers. So the first thing we're going to do is review kind of where states are with marijuana legislation. We're not going to go through every state. So this is not a webinar where I'm going to list every single state and how they handle it. The goal is for you to walk away from this webinar understanding what issues you need to watch out for and how to navigate them given how states have evolved on these matters. So the next thing we're going to do after we take a look at states is look at the interaction between medical marijuana use and medical accommodations, right? So there's this whole concept of use and accommodation in the medical world that then kind of can complicate things at the state level. We're going to discuss some state limitations on marijuana testing, and then we're going to get into the Drug-Free Workplace Act, right? So we're going to talk about how that really, Sarah's going to hop in and really talk about what you have to watch out for, what you can do, what you can't do. And then we're going to talk a little bit about best practices. So with that, let's hop in. Next slide. Okay, so we were very surprised when we looked at this again recently that 45 states and DC have legalized marijuana in some way, shape, or form. That could be marijuana itself. That could be CBD oils for medical or recreational purposes, which is a derivative. And we expect and have continued, we see this in our practice, that the number of people using marijuana in some capacity has increased. You can see that with the growing industry in marijuana drinks, right? So it's not people like teenagers just smoking at home anymore, or adults going to like, your local dispensary. There are, instead of alcohol, people are consuming drinks with some amount of marijuana or marijuana derivative in them. So we have seen those questions I talked about earlier really shift from someone tested positive to how do I hire people? Because it feels like everyone is going to test positive if I go down the road of drug testing. And yet I feel like this is something I should still be doing as an employer. So we're going to talk through that a little bit. Of those states, 24 and DC have fully legalized marijuana use. So I live in the District of Columbia. I cannot sell marijuana, but I can go to a dispensary and get marijuana legally. And I can share with my neighbors. I can even have plants in my backyard. I do not have plants in my backyard because I don't cultivate that well. But you could if you wanted to in DC. So that just kind of gives you an idea of the scope of the multi-jurisdictional issues we're talking about here. Next slide. So one of the first questions I get is, okay, Nicole, we have a pre-employment drug testing policy. We drug tested someone in Nebraska or wherever it is, insert state that has legalized marijuana. And they said, just to let you know, I'm going to test positive, but I have my medical marijuana card. And they sent me a copy of their medical marijuana card. Okay. So when I think about this issue, I think about this in terms of the pre-employment issues and the post-employment issues, right? So when I'm talking about pre-employment, the Americans with Disabilities Act, the federal law, excludes from coverage applicants or employees who are currently engaged in illegal drug use. And remember that marijuana is still a Schedule I drug for federal purposes. So for federal purposes, the Americans with Disabilities Act excludes employees or applicants who are currently engaged in illegal drug use. So if you have a drug testing policy that includes pre-employment testing and also reasonable suspicion or post-accident testing, and you test somebody and they test positive, it will not be an ADA issue, because from a federal perspective, it's illegal. It does not protect you, okay? There are carve-outs for prescription drug use that is within the legal range. So the employee's drug test is a medical record. It has to be kept separate from the rest of the personnel file. And you will see sometimes drug tests that come back as this is a legally prescribed drug. And then you go back and you get the prescription, and the drug testing company can usually tell you if it's within the prescribed range. So that's kind of how you would handle that piece of it. That said, if there is somebody that comes to you and says, hey, I have an addiction problem. Hasn't affected my work, but it affects me at home. I need to check into a rehabilitation facility. That drug addiction is a disability that is covered by the Americans with Disabilities Act. So in that respect, you have no proof that they've been using on the job. You have to be very careful that you don't make assumptions about the way someone's performing or their life because they've disclosed to you that they have this disability, and you likely need to make accommodations if they need to go to, say, meetings, or they need time off to go to a rehab facility. So that piece of it, during employment, I have a disability, I need an accommodation, and it's not because they tested positive, that will be an ADA issue that you need to contend with and move them through the normal accommodation process. Next slide. Okay, there's case law listed here. You can read these cases if you choose to read these cases, but I am going to give you the high level on, look, when we have medical marijuana issues and state disability laws, this is where you're going to have to watch out for pre-employment, or even post-employment drug testing issues, okay? Most of the issues I see in this world are the pre-employment drug testing issues. So someone tests positive for marijuana, they have, they have a medical marijuana card, and they want some accommodation for that. They basically want you to hire them anyway, right? And then that's where we kind of get into this issue of accommodation. Some states and some state laws expressly say that an employer can pre-employment drug test, and it doesn't matter if marijuana is legal in the state. If they test positive, you don't have to hire them. Some states, like New York, expressly prohibit pre-employment marijuana testing. So they say you cannot do it unless there are very specific reasons why you need to do it. Other states have cases, or they have a statute that's very similar to the Americans with the Disabilities Act. It's like the state law equivalent of that. And they say, hey, this could be an ADA issue that you need to accommodate. And by ADA issue, I mean like the state equivalent ADA, right? So for example, Oregon says, we do not protect medical marijuana use when we're dealing with disability. Connecticut says that the statute explicitly bars employment discrimination for marijuana use. So we can't discriminate against people. And then you've got other states like Massachusetts and New Jersey that are treating illnesses where people are treating themselves like cancer with medical marijuana, that we have to consider that as to whether or not we can give someone an accommodation for that disability. And you would run that person through your normal pre-employment or post-employment ADA process from a state law perspective. And so one thing you could say is, we're not going to hold your drug test against you, but you can't use while you're on working time, right? So that could be the accommodation, where I don't really care what you do at home, but when you're at work, I need to make sure that you're not using while you're at work, and you have somebody kind of, confirm that that's what they're doing. Mm-hmm. Okay, Sarah, were you going to chime in?
Yeah, well, no, I was going to say, first off, we had a question come in, and to reiterate that, by all means, feel free to send all the questions you have and we'll try to reach them. But an interesting question came up, and I figured we could talk about it a little bit, but essentially says, in the addiction case that you had described previously, how would the ADA intersect with employment terms requiring cleared individuals, so requirement for certain clearances, et cetera, maintain eligibility, where for purposes of that clearance, drug use would be considered adverse and could affect continued eligibility?
That's a great question. So the first thing you do when you have a clearance involved and someone discloses a drug issue to you is you connect with your FSO. So your FSO, or whoever's handling that within your organization, needs to assess whether the disclosure is a reportable incident to DISA or the agency that's involved with clearances. It is not your job as the employer to determine whether or not they can maintain their clearance. That is a different agency, right? Now it may be reportable, and your FSO may say, no, we need to report this to DISA or whoever you're working with, and they will make a determination as to whether or not that person can maintain their clearance. If they can't maintain their clearance, then obviously you can't keep them in that role, right? Because they have to be cleared in order to be in that role. But that's not really as much of an accommodation issue as it is, we have to report a disclosure, and then we leave it up to the agency to decide how they're going to handle that and whether or not they're going to keep this person cleared. Sometimes clients will say, well, I know they're not going to maintain their clearance, right? And I said, that's not for us to decide. We are not the agency that clears people. If it's a reportable incident, you report it, you step away, and then you handle the ADA issues separately, like whether the person needs time off to go to drug rehab or needs, shuffle the schedule for meetings. That's what you have to do from an employment perspective, and possibly report if it's a reportable incident. All right. Let's go to the next slide, please. So there are certain states that limit taking adverse employment action against employees for off-duty marijuana use, right? So we have again this difference between, particularly in the case of marijuana, where the effects don't usually stay in someone's system for a long time. So it's like kind of drinking, and the idea is they might test positive because drug tests aren't particularly sensitive right now to when you used, right? So the question then becomes, well, how do I accommodate for off-duty use? Somebody says, I've never used at work. I just, use a little bit at night or on the weekends or whatever the case might be. Well, there are certain states that say you cannot take adverse action because you learned that somebody is using marijuana off-duty. Okay, like New York City prohibits pre-employment drug testing at all for marijuana use. There are certain exemptions in many states for contract requirements and safety sensitive positions. Okay, so, and what I want to say about that is be careful about what you believe is a requirement, right? So sometimes we make assumptions. We're going to talk about the Drug-Free Workplace Act in a minute here. But sometimes we make assumptions about what is required and not required in our contracts. This comes up with citizenship a lot, like whether somebody has to be a citizen or not. It comes up in other issues. And the first thing we always tell clients is go back and check and tell me what you're basing. Give me the specific language in that contract that you're relying on to say that this is a contract specific requirement. Because I promise you, in New York, they are going to ask you that question if somebody complains. And if we want to have that answer ahead of time, right? And oftentimes what clients will say is Drug-Free Workplace Act. And as Sarah will talk about in a few minutes, pre-employment drug testing is not usually a requirement of the Drug-Free Workplace Act. So there might be certain contracts that specifically require it. And they say, like, for these positions, you must drug test. Or if you're doing Department of Transportation work or certain safety sensitive work, you might have exemptions under the statute for that, right? But we're really looking at that state statute to determine whether or not there is an exemption in the statute that would apply to that position, or whether the contract that you're working on specifically says you must test. So again, when I first started out, every company that I worked with pre-employment drug tested. Everybody background checked, everybody pre-employment drug tested. And that it kind of became standard to do that. Now, a lot of my clients call and say, Nicole, do I really have to pre-employment drug test? There might be reasons why you decide as an organization that you're going to do that, right? For example, maybe you are a company that has a lot of drivers and the insurance company wants you to pre-employment drug test as a way to mitigate insurance risk, right? Then we're going to look at the jurisdictions where you have people. We're going to make sure there's no issue with pre-employment drug screening in those jurisdictions, right? And then we're going to figure out how to handle those pre-employment drug screenings. And when somebody comes back positive and says they have a medical issue, are you in a state that then requires you to take additional consideration based on the ADA or some other issue? If you are not in a state that requires you to consider disabilities prior to employment when someone tests positive, then you can proceed not hiring and revoking that offer. You do want to make sure you go through all the steps when you revoke an offer, right? Of, giving somebody an adverse action notice, if you've done a background check, like doing all of that stuff, but you could proceed as you want to proceed. Many clients of mine who are not working in like safety sensitive industries or with safety sensitive positions, or the contract doesn't require it, maybe they have a lot of white collar workers. A lot of those companies have made a decision not to pre-employment test because it creates more issues for them. And they're not usually going to run into a situation where, they have an insurance issue or car accidents or anything like that, right? So the question is, I usually tell clients, why is it important to the company to pre-employment screen? And there may be very good reasons that are important for the company. And other companies are like, I don't know, we've just always done it, right? We thought we had to do it, so we've always done it. So that's the first thing is, do you want a pre-employment screen? And as I mentioned earlier, I like to think about things in terms of pre-employment and post-employment. So the post-employment considerations are, what kind of drug testing policy are you going to have for current employees, right? And there are generally a couple of different buckets of testing. There's reasonable suspicion testing. So every time I call this person, they sound high as a kite, and they're clearly not getting any work done. Or someone reported that, they saw them with contraband or something like that. There is post-accident testing, which is, I was driving for my job or something happened, and that kind of policy requires an employee be referred for testing regardless of whether there's any suspicion. So they get in accident, they go test. No favoritism, no anything. It's like accident, go test. And then there's randomized drug testing. That's the other kind of general category of testing. Unless you are in like a Department of Transportation program that requires certain randomized testing, or, I've worked with some construction companies over the years that for insurance purposes need to do randomized testing. I generally say stay away from randomized testing because most companies don't know how to manage a randomized testing program. It can't be like, well, we're gonna test Bobby, Joey, and Jane today, and in 2 months we're gonna pick 3 more names out of the hat. It has to be usually done through an automated randomized program. There are certain regulations that you have to comply with when you're handling a randomized program. So I generally don't recommend a randomized program unless there's a business need to maintain a randomized program. Okay, we have another question. Are you required to send a PAA/AA for positive drug screens if the positive test results are the reasons they are not going to get the job? Not technically, you don't have to. And what this person means by PAA is the pre-adverse action notice or the adverse action notice that's required by the Fair Credit Reporting Act. Technically, because it's not related to the background check itself or the credit check itself, the pre-adverse action notice and the adverse action notice are not required. That said, given some of these multi-jurisdictional issues, if you're in a you're either going to have different standard operating procedures for different states, right? Because let's just say you're in a state that has some sort of like Connecticut that says you can't discriminate against somebody and somebody for marijuana use in pre-employment world, and they test positive, and then you just revoke their offer, and they say, well, I told somebody during my interview that I had a medical marijuana card. That person just didn't convey it. Then we could have an issue, right? So I tend to, if I think I have a multi-jurisdictional issue, or if my company has got, or if the company I'm working with has gotten fairly large and doesn't have a fantastic infrastructure for the increase in people, sometimes I recommend just always doing the pre-adverse action letter and adverse action letter, because it gives people the opportunity to let you know what the mitigating circumstances. The response to that from probably most of you is, but Nicole, I don't want to invite this issue. Like, I don't want to deal with this. I have so much on my plate. I don't want to invite people to give me all of their, tiers and why they should be hired, and I've got to deal with it. And my response is, I would rather know what the excuse might be on the front end so I can manage that issue and take any maybe legally required action or prudent action to reduce risk on the front end, than deal with a protracted lawsuit on the back end, right? So I'd rather have the information. So it's not required. The adverse action notice is not generally required, but from a standard operating procedure perspective, I generally say it's not a bad idea, because it does kind of just standardize the process when you're rejecting somebody who's been made an offer, gives you the information you need to know to make the best decision possible, and you're not going to miss something, right, that comes up. All right, next slide.
This is kind of a repeat. Nicole touched on this in the prior slide, but essentially we did want to sort of highlight and emphasize that there are rather exceptions for government contractors when it comes to the pre-employment testing world. So while certain states do restrict pre-employment testing, there are a fair number of those state laws that allow for exceptions for government contractors, or usually the way that they word the exception is they tie it to, organizations that have received some federal funding, or if the employee is in a safety sensitive position, right? And to Nicole's point again earlier, we want to make sure that there is something that you could point to in the contract that allows you to sort of pull this exception and make it applicable to you, right? So again, there is a fair number of states that have the pre-employment testing restriction, but there is, this world of exceptions as it relates to government contractors, and it's very state specific. So you'd want to just make sure that you have a rundown, and a good idea of what those state requirements are. The next slide, we are going to dive into the Drug-Free Workplace Act. So just a little bit of background, not too long ago, so I think it was 1988 when Congress passed the Drug-Free Workplace Act, and it essentially required, organizations that either receive federal grants or, have federal contracts valued at $100,000 or more to essentially make sure that they're compliant with the Drug-Free Workplace Act. Now, we're going to talk through a little bit about what the Drug-Free Workplace Act actually requires, and then also talk about what it doesn't require, which tends to surprise a lot of folks when we tell them. But on this slide, we essentially have a list of what the requirements are, right? So essentially, what the Drug-Free Workplace Act requires, those who are recipients of federal grants or federal contracts valued at $100,000 or more, is you are within 30 days after receipt or after the award of the contract, you're supposed to publish a statement that essentially notifies your employees that, it's unlawful, that sort of catchphrase, right? It's unlawful to manufacture, distribute, dispense, and so forth, a controlled substance in the workplace, right? The statement must be provided to your employees, and then you are also required to sort of list out what potential personnel actions you may take for violations of that. There is also from the employee side a requirement to notify you, the employer, in writing if they are convicted under a criminal drug statute for a violation occurring in the workplace within 5 days of that conviction, right? So that is sort of an obligation that falls on the employee's end under the Drug-Free Workplace Act. And then there's also this requirement to sort of establish a drug-free awareness program. And basically what you're doing there is sort of what we talked about already, right? So what are sort of the dangers of drug abuse in the workplace? What are the penalties, right? Consequences for violation of that. You're supposed to also advise on any available rehabilitation, right? So drug counseling, employee assistance programs, things like that. Then you're also supposed to, along with that, have some sort of drug-free workplace policy, which we tend to see most clients do in like a handbook or in a separate policy that they distribute to employees. But that's really essentially it, right? So you have, just an obligation to report on the dangers of drug abuse, report on what your drug-free workplace policy is, and then also what potential penalties can occur as a result of violation of those policies. And then on the employee's end, you have that obligation to report any convictions within 5 days. So this is really what
narrow,
the right?
Yeah, it's pretty narrow. So if you think about it, I'm willing to bet, raise your hand if you do this, but I'm willing to bet most of you on this webinar or at home do not publish a specific notice to employees within 30 days of award. Your notice is your handbook policy. And I've always taken the position that that's fine. No agency or contracting officer has ever come out to me or a client and said, hey, did you post a separate notice that to employees on this contract that it's unlawful to manufacture, distribute, dispense, possess, or use a controlled substance? And most of the time, if it ever comes up, we say, here's our handbook policy, and everybody gets this upon hire. So it kind of checks off 2 boxes as far as I'm concerned, right? By having that policy in your handbook. And then the convictions are convictions with respect to drug use while at work, right? So like how many employees are convicted because of something that happened at work? It does happen, right? Like if you're on a military base and you're caught with contraband, that could be considered while at work. I had a client maybe 2 or 3 years ago now where this woman's boyfriend was making, what they call them, space cakes, which are basically pot brownies, at home at night, and she was selling them to coworkers at work. So she'd come in with her, brownies and sell them at work, and someone reported her. But in that case, no one called the police. She wasn't convicted. So we took appropriate personnel action because she was at work when this happened. So it's a violation of the act, and we took appropriate steps. But someone, I suppose, theoretically could have called the police. She could have been convicted for selling, marijuana or space cakes at work. And then she would have had to report that to us. And then the employer then has to report that to the contracting officer. So, you get the report, and then you have an obligation to report to the contracting officer, but that's pretty rare. And most policies that we see even say, we can take disciplinary action up to and including, termination of employment, but you're not required to terminate. Right. So that's the other interesting part, you're not required to terminate. So it's actually, I think the thing that most clients miss is this, like, what does it mean to have a drug-free awareness program? And is the policy itself enough? Probably not. But I would say most of our clients don't have like an official drug-free awareness program. They have the policy, and then maybe they have they let people know of an employee assistance program, so they have these different pieces that are, I think, we cobble together to say that that's our drug-free that's our awareness program. But it's rare to see a client that has like, hi, this is our drug-free awareness program. It's pretty rare to see that.
Yeah, I think usually with bigger clients, they might have sort of the resources to have something like that, but generally, it's not I don't think I've seen it very often. And on the next slide, we're going to talk about, you know, what the drug-free work or recommended components. Sorry, this comes next, but essentially we talked about this. I mean, just to sort of reiterate. So you want to make sure that the written policy, that's sort of, I think the key piece here is a written policy that sort of addresses, right, that the organization is, you know, going to maintain a drug-free workplace, and you know, these are sort of the different protocols and procedures that we're going to abide by. You know, if you want to put in any resources, employee education, employee assistance program, things like that. Supervisor training. So employers are generally required to provide training to their key employees, supervisors, right, managers, and they should be essentially able to recognize signs of marijuana impairment and be able to sort of take action and, you know, minimize the risk to the organization and figure out what corrective measures need to take place. So that training does need to happen as part of the requirements here. And then drug testing. So while the Drug-Free Workplace Act sort of requires organizations to make a good faith effort to maintain a drug-free workplace, there is no official requirement to actually do drug testing, right? Obviously, there are certain contract requirements or state laws that may impose some requirements to do so, but the Drug-Free Workplace Act in and of itself does not require drug testing. And we'll talk a little bit about this on the next slide, I think, about what the Drug-Free Workplace Act doesn't require. So if we can go to the next slide here. So the drug testing, right? And sort of to elaborate on that piece a little bit. So while the Drug-Free Workplace Act itself doesn't require drug testing, there might be certain contract requirements, or if you're working in like highly regulated industries. I know, for example, the Department of Transportation has certain requirements, again, because we're dealing with more safety sensitive positions, driving, things like that, that do impose the testing requirement, right? So it's not a blanket ban necessarily on drug testing, but you'd have to look specifically to your contract and what agency you may be working with to see if there are additional requirements that are imposed. The Drug-Free Workplace Act doesn't necessarily prohibit employees from drinking on the job. You don't need to monitor employee activity outside of the workplace. So again, this is just within the confines of the workplace itself. You aren't necessarily required to fire employees who fail a drug test. I mean, you should sort of take corrective action and determine what potential next steps you may need to take, but you aren't necessarily required, right, to take adverse action against an employee. And then obviously you also want to, like we talked about, be aware of any potential state laws, any contract requirements, right? So, you don't want the Drug-Free Workplace Act to preempt any additional requirements that are imposed under state law or under the contract that you're working on.
Which is a good question, right? Because some clients will say, but we have this Drug-Free Workplace Act, so it should preempt all those state laws you talked about earlier, right, Nicole? Mm-hmm. But the issues, like most all statutes and regulations in the employment world, the Drug-Free Workplace Act usually does not conflict with those state laws. They can be read together, and they can kind of move together to meet both objectives, the federal objective and the state objective. So unless we can show, where there is direct conflict, we're not going to have a preemption issue. So we have to comply with both, right? So for example, let's say you have New York City's pre-employment testing prohibition. It has an exception in there for when a contract specifically requires pre-employment drug screening, a federal contract. But unless we can point to a specific line in that contract that says you have to drug test pre-employment drug screen, including marijuana, we have to comply with both with the New York City law and the Drug-Free Workplace Act. So those things can work together, because remember, the DFWA does not require drug testing, right? Same with, firing employees that fail a drug test. It might be really easy to do a pre-employment because you've decided to pre-employment drug screen for marijuana in states that allow it. It's not a medical issue in a state. It's just someone used and didn't have it out of their system yet. That tends to be an easier question for employers than, I've had an employee that's worked for me for 15 or 20 years. They weren't driving a vehicle. They weren't in an accident. They were at home and something seemed off. And so we asked them to go get medical attention and include a drug screen because it was just a very odd day. And it just seemed like something was off, and it seemed like something was off, on a couple of different occasions. But for the most part, they were doing their job. They were, everything was okay. And the employee comes back and says, I'm so sorry. I don't know what I was thinking. I've had situations where parents have said, like the gummies situation. I've had a situation where somebody said, my teenager left these gummies on the table and I thought they were just gummies and I ate one. I don't know if they're lying or not. I don't know, who can tell if they're lying or not, right? But they're a 15 or 20-year employee with no other history. They've generally been doing their jobs. And then this comes up. Most employers are really hesitant to just fire somebody in that situation. So then we talk about what discipline is appropriate in those situations, right? Same with, I'm friends with a coworker on Facebook and I saw them post a picture smoking a joint or something. That's not a violation of the Drug-Free Workplace Act. So you can talk about whether or not they were representing the company poorly in making that decision to post. We could talk about other things, but that wouldn't necessarily be a violation of the Drug-Free Workplace Act, and it wouldn't require you to terminate them. Mm-hmm. So lots of complexities.
But also I think clients are usually very surprised that the Drug-Free Workplace Act is so narrow, right? They see this law and they think, oh my gosh, we have to do all these things and there's all these requirements, but it is sort of very specific and pretty tailored, I would say. And so, I think the biggest piece is the drug testing piece, and then, clients finding it kind of unusual that there is no requirement, but there isn't. And so something, again, to keep in mind, all that the Act requires is that you make a good faith effort to maintain a drug-free workplace, and then that you have these sort of required components that we talked about. But beyond that, there aren't necessarily that many, restrictions or requirements based on the Act. So. And then last slide here, I think, takeaways and best practices. So, given that this is a multi-jurisdictional webinar, obviously you want to make sure, if you're operating in a number of states, that you are checking those state law requirements. They are very, very different across the board. The language is very, very nuanced, depending on the state law. And so depending on, where you're operating, where you have employees in, it's obviously very prudent to go ahead and check those specific state laws and make sure that you're understanding the full scope of what those laws are and what the requirements are, because you'd be surprised, I think, to see that it really varies, right? And they may ultimately say the same thing, but the way that they say it and the requirements that they require of you for those things are going to be different. Another key piece is evaluating the position, right? I think we talked about sort of those safety sensitive positions. So, is that specific employee in a position or in a role or has job responsibilities that necessitate, right, sort of heightened obligations, and that you're going to consider, action based on their actual role and obligations. So someone who is in a, is a driver or, in a similar sort of safety sensitive position is going to probably have heightened legal obligations as compared to someone who is just a clerk or working on a computer, right, day to day. So you want to make sure that you understand the specific circumstances and the role that that employee is in. Obviously, if you are subject to the Drug-Free Workplace Act, that you actually have your Drug-Free Workplace Act policy, right, in place, and that have all of those required components that are required under the Act. And then obviously you want to just make sure that you're following state law. And then, as Nicole talked about initially, whether there is sort of an additional obligation to engage under, in the interactive process under state disability law or under the ADA, for example, right? So there's a lot of moving pieces to this, and I think it's so fact specific. And what state are you operating in? What's the employee's role? Is this sort of an ADA issue, right? So there's all these moving pieces, which makes this sort of a very complex and nuanced area to navigate. But I think once you have sort of an understanding of those foundational pieces, then it's sort of a step-by-step process from there.
And the places that we see some of the biggest issues, like when we're reviewing handbooks or when we're getting questions about this, are, first of all, we haven't looked at our drug-free workplace policy or our testing policy, which don't necessarily have to be the same policy. In fact, they could, often I will recommend doing your Drug-Free Workplace Act policy separate from your testing policy. They might be next to each other, but maybe not the same, right? Because they're not, because testing's not required by Drug-Free Workplace Act, they can kind of sit separately. And when somebody really reads it, I think the Drug-Free Workplace Act policy is one of those things that we just are like, it's there, and we move on. But when you really read them, you're like, what in God's name is this thing saying, right? Like it sometimes feels like it's been pulled from several other handbooks. So I would take the time and pull out your Drug-Free Workplace Act policy, read it, see if it's coherent, and see if it includes the components from the slides here that it needs to include. Is it duplicative? Does it have stuff in there that we don't really need anymore? A lot of times in handbooks, you'll see language where it's very clear that there was a situation with an employee like 5 or 10 years ago, and in reaction to that situation, we added a bunch of language, which really doesn't make sense to have anymore, right? So really take a chance to read that and read it separately from the testing obligations. Make sure that it's clear as to obligations. It's not just kind of a blurb that you have, but I like to really break out the obligations of that policy. And then take a look at your drug testing policy. Are we doing what we said we were going to do in this drug testing policy? Should we be doing it that way? And so now is a good time to think about, have we been doing or handling our drug testing policies the same way for 15 years or 20 years? Is it time to revisit what we do there? And the nice thing is, hopefully what you take out of today is that you have some flexibility to make some choices that I think people didn't think that they had, right? And there's no right or wrong answer necessarily. Some organizations feel very strongly about it. Other organizations do not. And there's no right or wrong answer. You just have to bob and weave through those state law issues, no matter which side you come out on, and you have some flexibility to build what's right for the organization. And maybe the organization says, we're going to stay the course and pre-employment drug screen. And maybe your organization says, why are we spending the money on this? Because we don't have safety sensitive positions. We don't really need to do this. The other big issue that I run into that I wanted to raise today is look at what companies you're using for your drug testing. So there are different kinds of tests now, and there are different labs. There are take-home tests that employees can do now and send in. But one of the issues that comes up all the time is, well, we don't do pre-employment drug screening anymore, but we do post-accident or reasonable suspicion testing. and I'll get a panicked call from somebody, and it's like, I have to refer someone to drug screening because there was an accident, and I don't know where I'm sending them because we don't have a relationship with anybody, right? So if you are going to have a drug screening process in place, understand what company you're engaged with or how you are conducting those that drug testing process. Obviously, if someone's inebriated, please don't have them get in their car, or you think that they're inebriated, don't have them drive to a drug testing center. There's Uber, Lyft, have a supervisor take them, have them call somebody, you know, but that comes up. Well, how do I get there? How do they get there, right? So have thought about those components. What's your standard operating procedure if you need to refer someone to testing while they're unemployed? How are you going to manage that process so that you don't make any, because those are right now decisions that you all have to make, right? They're decisions you want to have really thought about in advance. I usually get a handful of those panicked calls every single year about how we're actually going to do this, right? So that's really important. But so what I encourage you to do when you're, you know, when we're trying to get a whole handbook out the door, we're often just trying to get it out the door. It's been sitting, I got to get the update done, just trying to get it out the door. So what I would encourage you to do when you are engaging in a webinar like this, if you attended one of the first 3 about leave or whatever it was, I don't know if I can even, I think non-competes, I can't remember what the first one is. Yeah. It was been so long. Use these webinars as an opportunity to say, right after the webinar, I'm going to pull that policy. I'm going to pull those things while this is all fresh in my head. And I'm going to run through the scenarios that we talked about in the webinar to make sure that I've thought about not just the policy, not just what we're going to do, but let me run through 1 or 2 of these scenarios that might come up and make sure that I've really got my standard operating procedure down and my team knows what to do. And then the other thing that I wanted to just plug that I should have plugged in a few slides ago, but Sarah talked briefly about supervisor training. And it's like everything requires supervisor training, right? So what I typically recommend to employers, since this is the last in our series, is, you know, it's a good idea to have a global kind of management training every year, right? And that could include things like, how do you tell that there's reasonable suspicion to refer someone to training, right? Yeah. You know, I've had a lot of
judgment calls sometimes, yeah.
Right, you gotta make a judgment call. And some clients are like, I don't know if there's a health issue. Can I even ask them? Because I don't want to ask them about a health issue, but it's very clear that something's going on. And I'm like, ask them if they're okay, right? Like I'll call you, like, has anybody called this person and said, are you okay? You seem a little off today. You know, are you feeling well? It's okay to ask that question. It is, you know, I feel like we've gotten so sensitive to private things in people's lives, which is not a bad thing, but we're also humans. And if, you know, maybe it's a drug issue, maybe they're having a heart attack, right? So like, you should ask, you know, they have emergency contacts in place. But to go back to this idea of a manager training, you can cover a lot of the things we've covered in these multi-jurisdictional employer sessions, like, did I hire somebody that is only giving me a PO box? Do I actually know where they're physically located so I can make some of these determinations about where people are working and what law is covered? Things like, you know, your discrimination and harassment training for supervisors, what interview questions you can ask, right? How to handle disciplinary situations with employees. Those can be all kind of wrapped up in one management training, and you're ticking all of those boxes, right? About supervisor training all at one time, which is great, and it's really good support to give your managers and supervisors. You can conduct that yourself. You don't need a third party to do it. We do have some examples of it. Some clients do hire us to go and train managers about various things, and we can do that. We can also help you review the materials that you have to make sure that you're clicking all those boxes. So I just wanted to raise that. It's a good way to kind of, sometimes I get these sighs like, oh my gosh, Nicole, another training. Wrap it all up into one, right?
Yeah.
Like do a couple hour training with your managers and wrap it all up into one thing.
And some states require, I mean, you know, you've got states like California that require sexual harassment training, not just for your supervisors, but, you know, across the board. But, you know, you can certainly make sure that you encompass everything within that one sort of overall manager training, because a lot of these are going to be your frontline supervisors who work with these individuals day to day, that can be like, okay, you know, Jessica there looks a little bit off today. You know, I've seen her for the past, you know, a year or two or whatever, how long she's been employed. And so they are probably the best people to sort of make those judgment calls at the end of the day. Another interesting piece is a lot of, you know, employees now are working remotely, right? So, you know, how do you tell if someone is joining a meeting and seems a little bit off, right? And so you want to be able to sort of train and advise your managers and those frontline supervisors on the types of things to look out for, and more importantly, the next steps to take if they believe that something's going on. So I think that's really it. Contact information is up there. So if by all means, if there are any questions, I think we got to everything. But if there are any additional questions that come up, feel free to email Nicole and I, and we can certainly get back to you. But I believe this concludes our multi-jurisdictional employer series. So I hope it was helpful. I know, I mean, we deal with these issues day in and day out with our clients. So, I mean, that's really what prompted this series. But, you know, it does obviously get trickier the more states you operate in, given sort of this patchwork of state laws as it relates to everything these days. So it's prudent to sort of just be aware of, you know, where you have employees and what those state laws are requiring of you.
It's always a pleasure. Please give us some feedback. We always like getting feedback from you. You know, if you don't want to tell us how well we did, tell us what you want to hear about. Tell us what we can bring to you next, because we're always looking for topic ideas. And with that, we hope you have a great afternoon. Thank you again for joining us. And thanks to Kaylee for putting this all together.
Thank you, Kaylee. Thank you.